Good afternoon, everybody. Thanks for joining us with our talk with appellate lawyer Bryan Gowdy and a look inside a case that he argued before the U.S. Supreme Court. We're glad everyone could join us for that. Before we start talking about this case, I wanted to promote an event that we're having on March 10th. It is the 11th Circuit Year in Review, which is an event that we try to do each year. This year, we're dividing it into two events. The first one is going to be about the criminal docket of the 11th Circuit, and we have an all-star panel moderated by Michael Caruso, the federal public defender here in Miami, in the Southern District of Florida. And he's going to be speaking with U.S. District Judge and former public defender Kathleen Williams, Tamara Lawson, who's the Dean of St. Thomas University School of Law, also here in Miami, and the two chiefs of the appellate division of the U.S. Attorney's Office and the Federal Public Defender's Office. So it should be a great event, and would love for you all to register for it. If you go into the chat, you'll see a link to the registration, and you can register at that link, and hope to see you all at that event as well. For today's event, we did get approval from the Florida Bar for 1 hour of CLE credit, and we're going to be posting that towards the end of the event. We have a number already approved. The other thing I wanted to encourage everyone is to please post your questions in the chat or in the Q&A. You can use either one during the talk, because I think if the questions are, are relevant to what we're talking about at the time, then we'll just jump in and take the questions midstream. If not, we can hold some time at the end for questions as well. So now I would like to introduce our guest, Bryan Gowdy. Bryan, thanks for joining us. Many of you may know Bryan. He is an accomplished and well-known appellate lawyer in the state of Florida. He is board certified in appellate law, and he's argued scores of cases in every court, state and federal, in Florida. And this is actually his second case that he's argued in the United States Supreme Court, which is pretty rare unless you happen to be the Solicitor General of Florida, or maybe a criminal public defender. Even then, it's pretty rare to get one, let alone two cases, especially of any type. And Bryan's first case was pretty significant. He argued Graham versus Florida, which applied the 8th Amendment to non-capital punishments and declared unconstitutional life without parole sentences for juveniles in non-homicide crimes. So that was kind of a landmark case that Bryan won for his client. He, like myself, he's a proud graduate of the University of Florida Law School. Unlike myself, he graduated first in his class, and then he also was an editor on the Law Review, and then clerked for two federal judges, a district court judge, Maurice, who I think was in Gainesville. Is that right?
Yep.
He was in Gainesville, and then clerked in Jacksonville for Judge Susan Black on the 11th Circuit. He graduated from Georgetown School of Foreign Service and also served as an active duty surface warfare officer in the U.S. Navy, which probably, Bryan, gives you a perspective on the news that we're seeing in Ukraine, different from many lawyers, I'm sure. Bryan is the founder and the partner at his law firm, Gowdy and Creed and Gowdy. Is that right?
That's correct. Yeah.
In Jacksonville. So we're really glad to have you. Thanks for agreeing to come talk to us. about your case, which you just argued in January. It hasn't been decided yet. But before we talk about your current case, I wanted to rewind and talk about the other case you argued in the Supreme Court, Graham. And you shared with me a kind of an interesting story you had about prepping for that case and meeting Ketanji Brown Jackson, who of course has just been nominated to fill a seat on the Supreme Court. So tell us about that experience.
Sure. Well, thanks for having me. And definitely my thoughts are with the people in the Ukraine. I did get to go to there in Russia in the early 90s when I was in the Navy, and it's sad to see what's happened 30 years later. But yeah, Graham representing Terrence was a good experience as a lawyer, and my co-counsel on that case was, I got a large law firm involved because of the 50 state research we were going to have to do and so many other things we were going to have to do. And the name of that firm was and is Maurice and Forrester. They have some great people there, including my brother at that time. And Ketanji Brown Jackson was with the firm at that point back in, I believe she was there from 2006 to 10. And so I recall I would go up to Washington for the moots. And when I went up for the moot that we had at Georgetown, I got introduced to Judge Jackson. And obviously, because she clerked for Justice Breyer, they wanted her to kind of get involved in the case. She wasn't involved in the brief writing so much. But so she had a car and she offered to take me to Georgetown that day. She stayed for the whole moot, and she stayed for the post-moot critique. And it was a very interesting moot because there were some very, I'll just say, notable people in the room that day who you would probably recognize. That from all sides, that they try to get people from every persuasion, so you get a really tough moot, some really good lawyers. And then she drove me back to the Morrison and Forrest office, and she found me an empty office because I needed to do some work. And she spent some time with me, telling me what she thought about the case. And you know how lawyers brainstorm. So we spent some time doing that day, I remember. So anyway, I don't know her well. I'm not good friends with her. There's other people I know in Miami that are very, very good friends with her. But my one interaction with her was great. And I guess just thinking back was, of all the very high-powered lawyers in the room that day at Georgetown, it was the one person kind enough to offer me a ride and find me an office. They got the Supreme Court nomination on Friday, and that's terrific from my perspective.
Yeah, it just goes to show you never know who you meet, who's gonna, play some big influence either in your life or, in this case, in the nation's life. And of course, you got to be kind to everyone, whether or not they're going to be Supreme Court justices. But
well, I think from what I know about her, from other people who are better friends with her, that's what she is. She's kind to everyone. I think she has a real sense of humanity. And, she was very interested in Terrence's case, and I was appreciative of the time she was able to devote to it.
Yeah, so let's talk about this case. And having been through the process once before, were you looking for another vehicle to get to the Supreme Court, or did this just kind of fall into your lap? How did the case start for you?
Yeah, so I definitely was not looking to take this case to the Supreme Court. We were looking to take this case to federal court. I guess the backstory, it's about the Medicaid Act. And for those of you that aren't super familiar with that, it's a joint federal and state program. The federal government provides most of the funding, the states administer it. And so you have the federal Medicaid statutes, but then each state has its own individual statutes. And we thought that this one Florida statute conflicted with the federal statutes and was preempted. And we also, but most of these Medicaid cases dealing with tort recoveries are litigated in the Department of Administrative Hearings through in front of an administrative law judge. And my co-counsel was pretty sure we would lose in front of the ALJ he had drawn, and we weren't optimistic about our chances on appeal to the First District Court of Appeal. So we decided to file in federal court and file a deck action.
Let me rewind a little bit, because I know the argument and the briefs were very heavy on the statutory issues.
Right.
But there's a real human involved in this case. And tell us who that was and what happened to her.
Sure. My client is Miss Gallardo. She, when she was 13 years old, she got off her school bus like a lot of other kids do, and she was run over by a truck, and had catastrophic injuries that she's still suffering from today. 13, 14 years later, she's in a permanent vegetative state still today. And she, she got lawyers involved. Her family got lawyers involved, her mother and father. They sued the truck driver, the truck owner, the school district. Her medical bills are obviously just astronomical. Medicaid paid for these medical bills. They're over $860,000. There eventually was a settlement, and because of so many cases, you have various issues. Here we had problems with, well, first of all, the school district has got sovereign immunity, so there's limited amount you can get. And then there were issues with the amount of insurance available from the private defendants. So the amount of the settlement was $800,000, which is less than even her past medical expenses.
Wow.
And of course, she needs medical care for the rest of her life, from age 13 to however long she lives. And of course, she has pain and suffering and all types of other damages besides medical expenses. So, and she's still, under the care of her parents to this day, even though she's now in her, early mid-20s.
So it's not like this 800,000 settlement was really going to pay all of her bills or even remotely make her whole financially.
That's right. That's correct. It was not her, had she gone to trial and been able to get a judgment against the defendants, her lawyers believe they would have shown those damages, her damages, to be over $20 million. A large, substantial amount of that being for future medical care, not for the past medical expenses, as well as for her pain and suffering and other things like that.
So sometimes you get the settlement, the case is over, and then kind of everyone goes home or moves on to the next case, but that's not what happened here. What happened with that 800,000?
Well, so what happened with the 800,000 is that there was a lien that the state Medicaid agency had placed on the settlement. And under the Florida statutes, there's a formula, and we were required to place $300,000 of that settlement in a trust account until that lien was resolved. And so that was so the accident happened in 2008. The case didn't settle till about 2015. And then this would have been late 2015 or early 2016 that the money was placed, the $300,000 was placed in trust, and it's still there today, pending the outcome of the Supreme Court's decision that I argued in January, as well as further proceedings in front of the administrative law judge.
Wow, yeah, that's a long road. So why don't I show that slide that I prepared this slide, Brian did not. Just to put that on the record, but why don't we show that slide that kind of gives like a very rough estimate of like how the pie might be divided and how the state wanted it carved up and how your client, what she wanted. So let me put that slide on. Okay, there we go. Maybe walk us through what we're talking about here.
Sure. Yeah. So these are there still could be further litigation at the at DOA. So these are David's numbers, and I don't think the numbers are just sort of illustrative, but you do see on the left there in blue, I think this number everybody agrees to, the 300,000, that's the amount that the state is seeking, and that's the amount that we were required to put in the trust account. You also see at the top, the gray, those are the amounts for attorney's fees, and under the statute, there's 25% for that. What we don't have here, which I won't get into, is there are some costs, but those are pretty small. The bigger dispute is about the red area. And so if you think about a tort settlement, or I'm sorry, it's not about, well, it's the red and the blue. Those are the disputes, the red and the blue. And if you think about a tort settlement, it has various damages. You have, and I'll put these into 3 buckets to make it easy for everyone to understand, or hopefully easy. One bucket of damages would be pain and suffering, lost wages, property damage, anything that's not related to medical expenses, okay? The state of Florida concedes that Ms. Gallardo is entitled to keep the portions of the settlement allocated to those non-medical expenses. That's undisputed. A second bucket is the payments for past medical expenses paid by Medicaid. And most of Ms. Gallardo's past medical expenses were paid by Medicaid. There is a small amount that was paid by a private insurer. But, and so whatever portion of the settlement is allocated to past medical expenses paid by Medicaid, Medicaid is entitled to. And we say that amount is about $35,000, which is what you see down at the bottom on the right. And so now where the legal dispute is what about the portions of the settlement that are allocated for future medical care? And keeping in mind, Ms. Gallardo, from the moment of the settlement in late 2015, she could have another 60 years that she's going to live, in which she's going to need a lot of medical care for somebody who is in a permanent vegetative state. So the state of Florida's position is that they're entitled to the portions of the settlement for future medical care, and our position is that they're not. Now, just the last thing I'll say on all this is I know the numbers are up here, but the allocations will actually be done by the administrative law judge whenever we go back to that proceeding. And I think where we'll be fighting about is whether, the state of Florida gets up to 300,000 or gets as little as 35,000. And if the state of Florida is entitled to the portion of the settlement for future medical expenses, they're much more likely to get very close, if not that entire 300,000. if they're not entitled to that portion, then they're likely to only get about 35,000.
Gotcha. So you mentioned you all wanted to take this to federal court. Why not litigate it in state court?
Well,
What was-
most of these cases are litigated in state court. You litigate in front of the administrative law judge, and then you can take an appeal up to the District Court of Appeal, and then even from there to the Supreme Court of Florida, and from there to the U.S. Supreme Court if you want. But you know, this was a question of federal preemption, and I guess I would just say, in my general experience, you're more likely to get a federal judge to hold that a state statute is preempted by a federal law than you'll get a state judge, either administrative law judge or Article 5 Florida judge, to say that. So we felt our chances were better in federal court to win.
And you all did win in the district court in front of Judge Mark Walker, who wrote, I thought, a pretty lively opinion, at least the top, in your favor.
He did. He was very colorful in his opinion, and we won, and we were very happy at that point. And you know, at that point in time, when we won in the district court, things had happened over in the state system in another case called Geraldo, not to be confused with Miss Gallardo. And in Geraldo, the case, by the time we were in front of Judge Walker, it had gotten up to the First District Court of Appeal, and the First District Court of Appeal had ruled against our position. So we were glad to be in front of Judge Walker. And we sort of knew about the Geraldo case because my co-counsel represented Geraldo. What we didn't know about was there was another case going on in the second district that the second district ended up ruling, agreeing with Judge Walker's position and our position, and disagreeing with the first district. So anyway, these were all kind of going on. It's difficult to go back and trace when everything was happening, but I do know that when we started in the federal court, there were no DCA decisions at all. By the time we got a decision from Judge Walker, there was one decision from the first DCA and one decision from the second DCA.
Right. And then you go up to the 11th Circuit, and as I recall, you had a panel with Judge Branch, Wilson, and Anderson. And you lost, but you got a dissent, right? You got a dissent from Judge Wilson.
Yeah, I think the interesting thing was we argued the case in December of 2018. And so 3 months before we argued the case, the Florida Supreme Court resolved the conflict between the first and second, actually it was a little bit more than 3 months, but between the first and second DCAs. And the Florida Supreme Court agreed with our position, with Judge Walker's position, and with the position of the second DCA, and it reversed the first DCA. And by the time we got to oral argument, more than 90 days had lapsed from the Florida Supreme Court's decision, and the agency had not sought a petition for cert in the U.S. Supreme Court. And so I was feeling really good going into the oral argument because I would also point out the Florida Supreme Court decision was 7-0.
Wow.
And Justice Lawson wrote the opinion. There was a concurrence by Justice Polson that agreed in the result, but had some different reasoning. But under either the 6-judge opinion or the Justice Polson's concurrence, our Ms. Gallardo should have won. And we submitted that as supplemental authority not too long before the oral argument. But then
But you're stuck at that point. You can't jump back in state court, right? I mean, you're stuck. You're on appeal. You're the
Well,
appellee.
right. And I won't go through all that. We had some issues about whether there was something we could, to get the case out of federal court, but you're right, we were stuck. And then it took the 11th Circuit 18 months to issue a decision. And the dissent that Judge Wilson wrote, I think, was a little bit longer than the majority opinion.
Wow.
And the other thing that had everything's always evolving during these cases. The other thing that happened while we were in that 18 months that we were waiting, the Utah Supreme Court came out with a decision that agreed with us, disagreed with the first district. And that decision, the Utah Medicaid agency had taken a petition for cert to the U.S. Supreme Court, and it had been denied by the U.S. Supreme Court. So we submitted that as supplemental authority to the 11th Circuit panel. But then they came out with a 2-1 decision against us.
And, Judge Wilson, I was in front of a group of lawyers that he spoke to, and I remember he said, when I write a dissent, it's an invitation for one party to file a petition for rehearing en banc, which I thought stayed with me, that comment of his. But was there a petition, or did the court just sua sponte decide whether to go en banc or not?
No, we did petition. I accepted his invitation and we filed a petition for rehearing en banc, and which was a positive thing. We did get some activity out of that. The mandate was withheld, and we got a second round of opinions, a very short opinion written by the 2-judge majority, and then a further dissent by Judge Wilson. I would say the reason I was very happy to have filed the petition for rehearing en banc, I mean, it was denied, but in the majority opinion denying the rehearing en banc, it expressly acknowledged that its decision conflicted with the Florida Supreme Court and that the Florida Supreme Court was incorrect. And that which you could have already told from the first round of opinions, but to have the 2 judges in the majority expressly acknowledge that made it very easy for cert review, because you now had the Regional Court of Appeals and the state Supreme Court having diametrically opposed views on whether the exact same statute was preempted or not. So I think it was stronger than your typical conflict, because it wasn't like conflicting precedent. It was a conflict about whether this very same statute would be invalidated or not.
It's interesting because it's so hard to get cert granted. And there'd been that earlier cert petition denied. And I do hear what you're saying. On the other hand, it's just one state where there's this conflict, one state out of 50. So what was your thinking about getting cert petition? I mean, getting the cert granted, what was your strategy there?
Well, our strategy, I thought we had a pretty high chance. The last time that the U.S. Supreme Court reviewed this same set of Medicaid statutes was a case that came out of North Carolina called, some people pronounce it VOS, some people pronounce it WOS, it's WOS. But anyway, in that case, it was almost identical to what we had here. The North Carolina Supreme Court and the Fourth Circuit Court of Appeals had reached completely opposite positions on whether a North Carolina Medicaid statute was preempted by the federal Medicaid statute. And so I obviously went back and looked at those petitions and we just focused on that conflict. I think it is, you said it's just one state, but it sort of puts the state in a very difficult position because keep in mind and I guess just to fast forward, what ended up happening in this case is the respondent, the Agency for Healthcare Administration, acquiesced in our petition. The very first
Oh,
line in their response to our petition is the court should grant the petition. And
wow.
I think the reason that the agent, of course, I don't represent the agency, but if you are an agency, and keep in mind, Medicaid is about 30% of Florida's budget. Think about almost a third, and
Yeah.
you are administering this federal program, and you have to follow federal law, and you have the regional court of appeals that has jurisdiction over your state telling you X, and your state Supreme Court telling you the opposite of X, then you are, and this is what they said, the state in its response, you're in an intractable position.
Hmm.
So, and we made that same point in our petition, that the agency is now being told the completely different things by two courts with overlapping but jurisdiction over this agency. And Judge Wilson played that up in his dissent too, that you're going to have result X in federal court and the opposite of X in state court.
I looked at the docket and I was actually surprised there weren't too many amici briefs really for either side, either at the cert stage or even at the merit stage. I think there was only two for your side, if I'm remembering right. I mean, usually in these cases, there's like scores of amicus briefs filed.
Yeah, so there weren't a lot, and I think for this type case, it doesn't get the same attention as, say, a case dealing with guns, abortion, free speech, or religion. In the Graham case that you mentioned at the beginning, the juvenile life without parole case, there were 17 amicus briefs, 14 in favor. So what I would say is there's always two stages, right? There's the petition, and then there's the merit stage. At the petition stage, there were no amicus briefs at all. There was zero. I would have liked to have some amicus briefs, but I failed in getting any. What I did is I went. There's been two Supreme Court cases in this area. One is, I told you a minute ago, called Was, and then the other one from 2006 called Alborn. I went back, I looked at those cases, I looked at the organizations that found amicus, I contacted those organizations, but for reasons I don't really want to get into, nobody wanted to file an amicus brief at the petition stage. Once we got to the merit stage, we were able to get a little bit more interest, and you said two, there were, and I think I know why you said two. There were two private amicus briefs in support of us, and there were two amicus briefs in support of the state. There was a third amicus brief in support of us, which was a very important amicus brief, the most important amicus brief from the United States of America, from the Justice Department.
Right. No, absolutely. And I wanted to talk to you about that because that's a part of appellate litigation that practitioners on at least on the state court level really don't get a lot of exposure to, which is going to the Department of Justice and seeking their support, either for cert or in this case on the merits. I've worked with lawyers who do Supreme Court litigation in DC, and they sort of describe it as this like elaborate process unto itself to get the DOJ on your side. And I've had lawyers tell me like they've prepped for these meetings with the Solicitor General's office, like they're prepping for an oral argument, like it's intense. I don't know if that was your experience or not, but tell us, how did you get the US on your side? Because that's obviously a huge thing.
Yeah, that was my experience. It is like getting ready for an oral argument. So once the petition is granted, the Solicitor General will weigh in on, I don't want to say every case, and as a matter of fact, they did not weigh in on the Graham case 12 years ago, and that's another story I can talk about, which was a win since I was representing a criminal defendant in that case. But but they weigh in on it on almost every case that the court takes. So the thing to do if you get in that position is you should immediately contact the Solicitor General's office and say, hey, I'm here, I'm willing to talk, when do you want to talk? And I happen to know a few people there that I've gotten to know over the years. So I emailed the people I knew and they pointed me in the right direction. And what the Solicitor General does is they, they review the briefing from below and whatever else they can get their hands on. And then they hold, at least they did in this instance, and I think they do this all the time, they hold a meeting and they'll usually meet like back to back. Like they meet with one side and then they immediately meet the same day with the other side. And now, we've been in the pandemic, so they're meeting like we're meeting here today remotely. So I remember the day, I think it was August 2nd. It was early August, we met with them. And yeah, getting ready for that was kind of like a little getting ready for an oral argument. And we met with them for 50 minutes. And you meet not just with the lawyers in the Solicitor General's office, you're going to meet with lawyers from the civil division, as well as from the client agency, which in this case is HHS and CMS, and they have lawyers from there. And so, in the Zoom format, or wasn't Zoom, but it was, another remote format, you've got a screen up with a bunch of different boxes and you're talking to, maybe 6, 7, 8 people. And I wouldn't say they're as active as the US Supreme Court in asking questions. It's not quite that, but they're asking questions of you and you get about 50 minutes to talk to them. And then the last thing I would just say on all that, which we did, and in my other experiences that I've had with them, I've done this, you follow up in writing to kind of, because you don't have 50 minutes is still not a lot of time. So we did that. And then you don't know which side the Solicitor General is going to take until the Solicitor General files her brief.
Oh, wow. Well, it's interesting that she took your side, because one might think she would, she would take the side of having the states get as much money back in their pockets as possible, because it's more money for government. And, I mean, I know there's arguments about this that we don't have to go down, but, arguably it helps the financial purse of the program. Although I saw the brief that made the opposite argument that it actually doesn't. But putting that aside, it was kind of surprising they took your side, at least to me as like an outsider to your case, not knowing the issue super well. But were you surprised? I mean,
I guess I'd say I was pleased.
Okay.
I definitely, I can tell you the night they didn't file the brief, the deadline of the brief, it's 1 week after you file. It's 1 week after we filed our brief, all the amicus supporting us had to be filed. So you mentioned we had 2 private amicus. They filed their briefs before I left the office at 5 o'clock. The government didn't file its amicus brief until after 7 p.m. And I was dancing in my kitchen. I was very happy. Okay. It felt like a win. So I don't want to say I was shocked, but I was definitely happy when they filed the brief, because it's a significant thing. And to your point about you might, yes, expect the government to take the side of the state and the federal government to take the side of the state government, because they're both, trying to, it is financed by both the federal and state government, and they're trying to get all their money back. But I think actually that, the Assistant Solicitor General who argued the case really put it best, which is that, Medicaid is, it's a benefit for people who need medical care. It's not about just maximizing the government's coffers. It's about taking care of people like Miss Gallardo. And they saw that you know, they, first of all, they look at the statutory text like any lawyers do. And you know, I think they thought our argument was supportable, but that's the policy of Medicaid. It's not to maximize money for the state. It's to take care of people like Miss Gallardo.
Well, that is true. That's true, although sometimes government doesn't work that way, as you know. Well, let's do this. We have 20 minutes. I want to spend the bulk of it talking about your Supreme Court argument, but just real briefly, maybe set up for us the statutory issues, because it is a statutory case. And if you want, I
Sure.
could put the slides on with the key statutory language.
Yeah, sure.
Maybe
That's
just
fine. Hopefully
walk
nobody
us
will.
through that briefly. Let's see.
So yeah, I would say there's a series of provisions, but the two that are on your screen now have been in the Medicaid Act since its inception in 1965, and they overlap. And I'll really just focus on the anti-lien provision. As I told Justice Gorsuch during the oral argument, this is a statutory property right. If you receive Medicaid, the federal government has said that the Medicaid agency isn't your creditor. They can't come back and try to recoup that money. That's what the anti-lien provision provides, which is, you know, different than other medical providers, right? Or other, if you have any type of tort suit, you have all types of lien holders. Well, this is the anti-lien statute. It says, no, this is a benefit. It's not a loan. And therefore no lien may be imposed against the property of any individual prior to his death on account of medical assistance paid. And then it doesn't just apply, this statute doesn't just apply to a tort settlement. It applies to your car, or let's say somebody on Medicaid wins the lottery. They get to keep the lottery money. They don't have to pay back Medicaid. Or say they end up having their business turn around and they come out of it and they no longer need financial assistance. Well, they don't have to pay it back. That's the baseline. And so I don't know if you want to, and the anti-recovery provision is similar. But then what's happened over the years, there's a third provision that's not up here, which, because we don't want to overwhelm you, but there's been a series of amendments that have kind of cut back on that original anti-lien provision from 1965. There was a provision enacted in 1968 that's called the third party liability provision. And then there was this assignment provision in 1977 and the payment recovery provision in 1993. And all of them collectively recognize that Medicaid can recover from third-party liabilities. Not so they can't come and get your car, they can't come and get your house, they can't come and get the money you win the day after you have Medicaid, but they can come and get certain third-party liabilities. And the dispute here is over what third-party liabilities. And in earlier cases, the courts made clear that when you're dealing with tort settlements, Medicaid's not entitled to those third-party liabilities that pay for non-medical expenses, pain and suffering, lost wages, things like that. But the question here again was, could they get from the future medical expense? And what the state hangs its hat on is the assignment provision, which is at the bottom of the screen here. And you'll see at the bottom there, assign the state any rights. And that's Florida's provision that it's relying upon mainly, and we had to argue about. We're relying more on the payment recovery provision, which says for healthcare items or services furnished to an individual. In other words, it has to be a third-party liability for something that Medicaid paid for. And so the way Judge Wilson, and you mentioned in his dissent, he says there's a conflict between these two provisions, but he applied, he decided the payment recovery provision in his dissenting opinion superseded the assignment provision because one, it's the more recently enacted provision, and two, it's more specific to what we're dealing with here. Of course, the majority didn't agree with them, but so that sums up the argument.
Okay, great. Well, and it's funny, Scalia during the debates about whether to televise oral argument would say, 90% of our cases are these dry statutory cases that no one would ever tune into. and this may be one of those, Bryan. But
Yes.
but super important. And kind of like with that in mind, how did you prepare for the oral argument and presenting your argument to this court? I mean, obviously it's a very sophisticated court, so there's no need to dumb it down for them, obviously, but still, how did you go about, what was your strategy for
the argument?
Yeah,
sure. I think, like any argument, obviously be prepared. I think the challenging part, as you mentioned, is it was completely text-based, and there's been a lot of commentary over the years about how dense and difficult it is to read the Medicaid Act. So, one thing I had there at the podium, obviously a little cheat sheet, and I just had to be very super familiar with the precise words and be able to really, I really tried to quote the words when I could, because the words were so important.
Is that the only thing you brought to the podium?
I'm sorry?
Is that the only thing you brought to the podium?
No, I brought the main briefs, and here's one of them I can flash in front of you. It's still got my little things on it, but I had the briefs, and I did refer to this during the argument. I know Justice Barrett asked me one question and I was able to get the right page number for her. But yeah, I know I had a 2 or 3 pieces of paper, but the main thing I had in me was with this table that had the statutes and all the, the key language in it. Yeah, so, but it's, as far as I guess preparing for the case, it was just like any argument, trying to think about any question they might have. We did moots. I did not see, a lot of time, I guess when I argued the last case in 2009, you kind of, in that case, you kind of knew where the justices were on the meaning of the cruel and unusual punishment clause, and you knew I was going to have justices who were not in my favor, and there would be justices that were in my favor, and then there would be some middle of the road justices. When you're dealing with like a statutory text case like this, and there's been 2 seminal cases before. One was 9-0, one was 6-3. It's really hard to know where anybody's going to be. I mean, it's a case that I don't think the typical, ideology that we see, we could, who knows what the outcome will be here, but it could be one of those cases where you don't see that normal breakdown. And so that's challenging for the oral argument, because, it's not like you can say, well, that person's never going to go with me. I'm going to try to get away from that person, that justice, because they're just against me, and I want to answer their questions in a way to persuade these justices. That wasn't this. You wanted to try to persuade each and every justice, because they're all, I think, in play, so to speak.
That's interesting. And some of the stories after the argument kind of made that clear, that it wasn't really clear which justices were in which camp, other than maybe Sotomayor. I don't know if you saw that. I read one article, Robert McCann's article, who said, like, okay, her position was clear. We'll see, I guess. But
I mean, I don't want to say she did. I guess what this is, you know, what happened at the argument, she did ask a series of questions where I think I just kept saying correct.
Yeah, right.
So that's usually a good sign that that person, when you just, you know, you just have to say correct. But yeah, I think it's fair to say that nobody can predict how the court will, you know,
So,
will predict the case, or will decide the case. I'm sorry.
yeah, yeah. Well, in terms of, tell us a little bit about the COVID protocols and how the argument differed with those protocols in place this time compared to last time. I mean, one thing I've read is that the Supreme Court arguments, you're really up close to the bench, and it's kind of, you're right in their face. I don't know if that's changed because of protocol, if they moved you back, but what are some of the differences that you see?
Yeah, so that has changed. It was a different experience from when I argued there last time because of COVID. I guess just starting with where you started, I don't, for anyone who's been in the U.S. Supreme Court, you know, and hopefully they'll reopen it. I remember going up there just before the pandemic with my oldest son, and you know, you can look in the courtroom, just the general public. You know, it's a fantastic courtroom, and as David described, the podium in the past before the pandemic was so close to the justices that, for, you know, a couple of things. One is you have a difficulty seeing the justices on the end of the bench because they're on your peripheral vision. You're that close. And the second thing that people have always said, though I've never tried this, is that if you leaned over the podium and the Chief Justice leaned over the podium, you could shake hands. I think you were that close, but, and then behind the podium in the pre-pandemic era is the bar section where they have all these chairs. And you can read about this, you know, if you go back and you read about when Thurgood Marshall argued, there was always been this bar section where the members of the Supreme Court bar can come and sit. There's a line for that. Well, because of the pandemic, all those chairs were out. They're all gone. And they moved the podium back considerably. And I had no problem seeing the justices on me. The justices were all well in front of me. I could not have, if I had leaned over the podium, I would have, I maybe could have thrown a baseball to the Chief Justice, but I couldn't have shook his hand. So that aspect was very different. You weren't as close. And then the other aspects that are different is they severely limit who's allowed in the courtroom. Typically you can have four, you know, the arguing counsel plus three other lawyers sitting at the table. They said you could have just the arguing counsel and one other lawyer. You know, no members of the public. There's a few members of the press. The law clerks are allowed there, though. We didn't have a lot of press or law clerks for this argument, but I've read in other cases they did. And then I think just the last thing that is noteworthy, and I guess we'll see what happens, is, you know, 24 hours in advance of the argument, you take a COVID test. And if you fail that test, if you have a positive, then you have to argue by telephone.
Wow.
And I know that's happened to at least 3 advocates, maybe more this term. And that was pretty nerve-wracking. I have to say, I think I was more nervous about whether I was going to pass my COVID test or not.
Wow.
So, and of course, you had to have N95 masks the whole time you're in there, except for when you were speaking at the podium.
Oh, wow. Well, when we talked to set this up, you had mentioned to me, I thought that the way the new format of how they do oral argument is really unlike other courts. And I thought you told me you liked it. Maybe I misremember that, but tell us about that.
Yeah, I think it's a great format. I wish at least like state Supreme Courts and would go to this when you have, you know, 5, 6, 7, 8, 9 justices. The format works like this. You get 2 minutes of uninterrupted time at the beginning. And then when you're done with that, you're required to pause or somehow signal to the justices that you're done. I think a lot of people now are saying, I welcome the court's questions. I just said, finally, finish that sentence and then paused. And so that pause is designed to let the justices start to ask questions. And since they came back in the courtroom from the pandemic, not always, but I think almost always, Justice Thomas is now asking the first question, which is a dramatic sea change from the last 30 years when or 28 or 29 years that he rarely asked questions. So then you have your argument time, which is typically 30 minutes, but if the Solicitor General's involved, they add another 5 minutes to each side. And then you've got to get, since the Solicitor General was supporting me, the lawyer arguing for the Solicitor General, got 15 minutes and I got 20. And that 20 includes my rebuttal time. So when I was done with my main argument, they then turn the clock off and the Chief Justice goes down the line and ask each justice if they have an additional question or two. And those are untimed questions. And they do that for each of the three advocates, both the petitioner, the respondent, which was the state of Florida in this case, and then the U.S. Solicitor General. So, even though the scheduled argument time was an hour and 10 minutes, because of the untimed questions, the argument lasted an hour and 45 minutes. So we had 35 minutes of untimed questions, the three of us. And I think that's great because, the justices, I think any question they wanted to ask was asked. And I think that's, now I know every court in this country can't spend an hour, 45 minutes on argument, but I felt like it wasn't when I argued last time, the justices were constantly cutting each other off and the advocates.
Right.
I didn't see that this time.
It's interesting because listening to the arguments, I've got to tell you, I enjoy the old format better because I feel like you hear the justices talking to each other more sharply, whereas this seems very staged in a way because they each go during that period separate, and you got less back and forth. So
yeah, fair point.
I haven't enjoyed it listening to it, but different. I'm not in the shoes you're in, and
yeah, no, that's true. That is different. Yeah. Well, I mean, it's, I think just, you mentioned it's a dry case, and I think that's accurate, yet they spent an hour, 45 minutes talking about it.
Right. And that's a long time. And I thought one thing the U.S. Solicitor General or Assistant or Deputy Solicitor General.
It's an assistant, but yeah, go ahead.
Yeah, an assistant did that was effective at the beginning of his time is he kind of went around to each of the justices and addressed their questions in a very 1, 2, 3 deliberate way, which I have heard before, but I don't think it's so easy to do in the old format when they're cutting each other off. I don't know if you've seen that strategy or what do you think of it?
I thought he was fantastic. I really thought his name is Vivek Suri. I thought he did an unbelievable job. I was really in awe, to be honest with you, the way he got up and he handled that. And I wish I could do it like that. Of course, he had the advantage of hearing all the questions that were asked of me. But if you're the appellee or you're the second person up for some reason, it was very effective, I thought. And I'll tell you, he didn't have any notes.
Wow.
He just had his brief. That's all he took up there.
That's remarkable. Yeah.
He was very, very, that was his fourth argument, I believe. I looked up and he was, I thought, very impressive.
Yeah. Well, and the state solicitor general did a good job too. And,
yeah. And I do thank you for telling me that he did.
Yeah.
he did an excellent job himself. I wasn't trying to say he didn't.
Oh, no, not at all.
But yeah, he did do an excellent job.
Gotcha. Well, it seems like the case could have a significant impact on obviously the Medicaid Act, and obviously, on tort recoveries and people who find themselves in the situation that your client's in. So we will see what happens. It's been an hour, so we should wrap up. I don't see any questions, but just wondering if you have any kind of last thoughts or comments that you want to.
I don't have anything. I'm happy if anybody wants to contact me afterwards with a question, or if you do have a petition. Somebody sent me one this morning, asked me to give it the 20,000 foot view. I'm always happy to try to help people out when I can. And, I just appreciate you hosting me, David, and to talk about, Miss Gallardo's case. One thing I'm very proud about my practice is that I normally represent individuals like Miss Gallardo, and hopefully we'll get a good result for her.
Yeah, I hope so. I really appreciate your time, Bryan. I just want to do two things before we sign off. One is make another plug for the 11th Circuit Year in Review, it's March 10th. Michael Caruso, who's our federal public defender, is a fabulous lawyer, very bright. It should be a great discussion, as are the other panelists as well. Judge Williams is sharp as they come, so is Andrew Adler. I don't know Emily, but to have the job she has, I'm sure she's terrific too. And then the all-important last thing to share with you all is the course number, so you can get your Florida CLE credit. It is up there on the PowerPoint 2200745N. That's 2200745N. If you miss the number, you stepped away, email me and I'll send it to you. I think ACS may also will also send it to you as well, if I'm not mistaken. So anyhow, Bryan, thanks so much. We appreciate your time and all the good work you're doing and your interest in ACS, and everyone have a great day.
Thank you.